One wrong sentence to an insurance adjuster, and it can cost you thousands of dollars in compensation or even destroy your case entirely. And they know exactly which questions to ask to make that happen. In this video, I'll show you what to never say when talking to an insurance adjuster after a car accident in Kentucky or Indiana, so you can protect your rights and avoid these traps they set for every injured person. Hi, I'm Carl Truman. As a retired United States Army officer and an attorney for over 34 years, I've helped thousands of people across Kentucky and Indiana with fair compensation after serious injuries. If you or someone you love has been hurt, don't face the insurance companies alone. Call me at 502-222-2222 and count on the Colonel. Let's start with something most people don't understand. The insurance adjuster is not your friend. They might sound friendly and they act concerned. They want to say they're going to help you, but their job is to save the insurance company money by paying you as little as possible. And the easiest way to do that is to get you to say something that they can use against you. Every word you say to an insurance adjuster gets documented, analyzed, and used to build a case against you. They're trained in specific tactics designed to make you feel comfortable, so you'll let your guard down and give them ammunition to deny or reduce your claim. So let's go through the most common situations where people talk to insurance adjusters, what gets said, and how to protect yourself. First situation, the call from your own insurance company. After a car accident in Kentucky or Indiana, you're required by your insurance policy to report the incident to your own insurance company. You have to make this call, but when you do, be strategic about it. When you call your own insurance company, here's what you should say. Stick to the basic facts only. Provide the date, time, and location of the accident. Give them the other driver's name and insurance information, and tell them you're seeking medical attention or that you've already been to a doctor. And that's it. Here's what you should never say to your own insurance company. Don't give a detailed account of how the accident happened until you've consulted with an attorney. Don't speculate about fault or blame. Don't say things like, I'm fine, or I'm feeling okay, when you haven't even been to the doctor or be evaluated yet. Don't guess about the extent of your injuries, and absolutely don't agree to give a recorded statement without talking to a lawyer first. Why does this matter? Because even your own insurance company is looking for reasons to minimize your claim, especially if you're making an underinsured or uninsured motorist claim against your own policy. They'll use your own words against you. If they push for more details, you can say, I'm still receiving medical treatment and evaluating the full extent of my injuries. I'll provide a complete statement once I've consulted with my attorney. That's perfectly acceptable, and it protects you. The next situation is the call from the other driver's insurance company. This is where people really get destroyed. Within a day or two after the accident, an adjuster from the other driver's insurance company will call you. They'll sound sympathetic. They'll say they're just trying to understand what happened, or they want you to get this resolved quickly for you. So here's what you need to understand. You have absolutely no legal obligation to talk to the other driver's insurance company. None. They have no authority over you. You're not required to give them a statement, answer questions, or cooperate with their investigation in any way. So here's what you should say when they call. I'm not comfortable giving a statement at this time. Please direct all communication to my attorney. If you don't have an attorney yet, you can say, I'm still evaluating my injuries and my legal options. I'm not giving any statements right now. That's it. Be polite, but be firm. Don't let them guilt you or pressure you into talking. Here's what you should never do with the other driver's insurance company. Never give them a recorded statement. Never sign anything like a medical authorization that they send you. Never accept any settlement offer without consulting an attorney, and never ever let them engage you in a casual conversation about the accident, your injuries, or how you're feeling. Why? Because they're trained to trap you. Let me show you how. The most dangerous questions insurance adjusters ask, and why. Insurance adjusters have a playbook of questions designed to get you to say something that damages your claim. Let's go through the most common ones so you can recognize them. Question 1. How are you feeling? That sounds innocent, right? They're not just being nice and asking about your well-being, but here's the trap. If you say, I'm fine, or I'm okay, They document that, and later they'll use it to argue that you weren't seriously injured. They'll say, "You told our adjuster you were fine just 2 days after the accident. Obviously, your injuries aren't that serious." The truth is, many serious injuries don't show symptoms immediately. Whiplash, herniated discs, soft tissue injuries, concussions, these can take days or even weeks to fully manifest. But if you've already told the adjuster you feel fine, you've given them ammunition. What should you say instead? "I'm still being evaluated by my doctor," or "I'm following my doctor's advice and attending all my appointments." If they push, simply say, "I'd prefer not to discuss my medical condition until I've completed my treatment." Question 2. Can you describe exactly how the accident happened? Sounds like a reasonable request. They're just trying to understand the facts, right? Wrong. This is one of the most dangerous questions they ask because they're looking for any statement that could shift blame on you or create inconsistencies they can exploit later. Here's how this plays out. You're stressed, you're in pain, you might be on pain medication, and you're trying to recall a traumatic event that happened in seconds. You might get a detail wrong or describe things in a way that sounds slightly different from what you said in the police report. The adjuster will jump on any inconsistencies and use it to argue that you're lying or you're at fault. In Kentucky and Indiana, we have a comparative fault system. So if you're found to be any percentage at fault, your compensation gets reduced by that percentage. The insurance company knows this, so they're trying to get you to say something that helps them argue you were partially to blame. What should you say instead? The police report documents what's happened, and I prefer to have my attorney discuss the details of the accident with you. Don't try to reconstruct the accident from memory while you're on the phone with someone who's trained to twist your words. Question 3. Were you injured in the accident? Another seemingly innocent question, but it's loaded with danger. If you say no because you're trying to be tough or because your symptoms haven't fully appeared yet, they'll document that and later they'll use it to deny your injury claim. If you say yes, but then downplay it or say, "It's not that bad," same result. What should you say instead? "I'm under a doctor's care and following their treatment plan. I'm not prepared to discuss the extent of my injuries at this time." Question 4. Had you been drinking before the accident, or were you on your phone? These are direct attempts to establish fault or suggest that you were negligent. Even if you had 1 beer with dinner 3 hours before the accident, if you say, "I had a drink," they'll document it and argue you were impaired, even if your blood alcohol was well below legal limit. What should you say? "I was operating my vehicle legally and safely." The police report addresses any questions about the cause of the accident. Question 5. Do you have any pre-existing injuries or medical conditions? This is a trap question designed to give them grounds to argue that your injuries are pre-existing and not caused by the accident. Kentucky and Indiana both recognize that you can have an aggravation of a pre-existing condition, but the insurance companies will still twist this information to deny your claim. What should you say? "My medical records will show my condition before and after the accident. My attorney can discuss this with you." Question 6. Can you sign this medical authorization so we can review your records? Sounds reasonable because they need to verify your injuries, right? But here's what they're really doing. They want unlimited access to your entire medical history going back years so they can dig up anything they can use to argue your injuries were pre-existing or unrelated to the accident. What should you say? "I'm not signing any authorizations without my attorney reviewing them first." What about written statements or forms they send you? Insurance companies will also send you written forms asking you to provide a statement or describe your injuries. They might send medical authorization forms or settlement releases. Don't fill these out and send them back without having an attorney review them first. These forms are carefully worded to protect the insurance company, not you. You might think you're just providing basic information, but you could be signing away important rights or admitting to things that hurt your case. The only information you must provide in Kentucky and Indiana, there are very limited circumstances where you're required to cooperate with an insurance company. You must report the accident to your own insurance company as required by your policy, but you don't have to give them a detailed recorded statement without having an attorney present. And you have absolutely no obligation to talk to the other driver's insurance company at all. Why insurance adjusters push so hard? You might be wondering, if I don't have to talk to them, why do they push so hard to get me on the phone? Because they know that the sooner they can get you to talk, the more likely they are to get you to say something helpful to them. They want you to lock in your story before you've had time to fully understand your injuries, consult with a doctor, or talk to an attorney. They may also know that most people want to be helpful. You're a good person. Someone's asking you questions and your instinct is to answer them. They're counting on that. They're counting on you not knowing that you can say no. What happens if you've already given a statement? If you've already talked to an insurance adjuster and said things you shouldn't have, don't panic. It makes your case harder, but not necessarily fatal. An experienced attorney can work around problematic statements by providing context, correcting misunderstandings, and building a strong case with medical evidence and other documentation. By going forward, stop talking to them immediately, politely decline any further communication, and tell them to contact your attorney. The right way to handle insurance communication. Here's the bottom line. The safest approach is to let your attorney handle all of the communication with insurance companies. When you hire a personal injury lawyer, one of the first things we do is notify all the insurance companies that we represent you and that all communication should go through us. This protects you in multiple ways. They can't call you and ask trick questions anymore. They can't pressure you to wear you down. We handle all the negotiations. We provide the information that they're legally entitled to, and we protect your rights through the process. And remember, most personal injury attorneys, including my firm, work on a contingency fee basis. You don't pay anything unless we recover compensation for you. So there's no financial risk to getting professional protection from these insurance company tactics. Your words matter more than you think. I've seen cases worth hundreds of thousands of dollars get reduced to a fraction of their value because someone said, "I feel fine," in a casual conversation with an adjuster 2 days after the accident. I've seen clear liability cases turn into comparative fault disputes because someone tried to explain what happened and accidentally said something that sounded like they might have been partially to blame. Your words matter. The insurance companies know this, which is why they work so hard to get you talking before you know better. Now you know better. If you've been injured in a car accident in Kentucky or Indiana, call my office at 502-222-2222 for a free consultation. Don't try to handle the insurance companies on your own. We'll take over all the communication with the insurance adjusters, protect you from their tactics, and fight to get you the full compensation you deserve. Remember, you can count on the Colonel. And if you want to avoid the other critical mistakes that destroy car accident settlements in Kentucky and Indiana, watch my next video where I reveal the biggest mistakes people make after a crash and exactly how to avoid them.